Helen Grant.
I was a legal aid family lawyer for 23 years prior to becoming an MP, and my husband continues to run our firm in Croydon, and I will declare an interest in this debate. The government plans to reform legal aid are brave and bold, and I know that the consultation has been taken very seriously, and I also know that important concessions have been made, but I continue to have some serious concerns. The plans rely upon people being able to represent themselves. But what about people with learning difficulties? What about people with limited English? What about people with mental health problems? These people cannot help themselves. They can't do it. The plans rely on our hard-pressed voluntary sector dealing with the fallout from the legal sector, but our not-for-profit organisations are already overstretched and under-resourced. And actually, not-for-profit doesn't mean no funds, please. Yes, I will.
And would my honourable friend agree that Citizens Advice Bureau, like South Hams, many of them, like my own, receive 55 to 65% of their funding from legal aid, and are also very concerned about the time frame of the proposals, with the proposals being introduced in October?
I think my friend makes a very good point, and I do think change must be paced. But picking up where I left off, not-for-profit doesn't mean no funds, please. They still need cash just to stand still, let alone deal with the massive glut of cases that will fall into their laps. But I am reassured and encouraged by what my honourable friend said about an additional sum of some 20 million, which will be directed towards them, which I think is very positive indeed. The plans rely on judges and magistrates and chairmen of tribunals having the time to assist numerous litigants in person. But I can honestly tell you that time doesn't exist, because judges already have back-to-back lists, and delays in court will become even worse. The plans rely on less dependency on legal proceedings, but mediation, as I've said before in this place, is no panacea. It frequently fails, especially in family cases, where there's often an imbalance of power between the parties. And where are all these mediators going to come from, and who's going to pay for them? The plans see telephone advice as an alternative to a trusted and recommended solicitor. But the law can be complicated. The law is not easy to understand. Yes, I will.
I'm grateful to my honourable friend for giving way, and I'm following her very sincere and very important remarks very closely. But on mediation, wouldn't she agree with me that the advantage of mediation is that you bring people together, you actually reduce the disputes in circumstances of family life, and in doing that, you achieve something worthwhile in itself, and it is the right way to go, even though I accept that there will always be some cases which need to be litigated.
The problem is that not all cases can be mediated, and it's usually the difficult ones that end up in court anyway, and those are the cases that we're currently dealing with. The plans see telephone advice as an alternative to a trusted and recommended solicitor, but as I was saying, the law is complicated, the law can be an ass, the law is not easy to understand. Just try explaining maintenance pending suit or some other aspect of the Matrimonial Causes Act to a frightened and vulnerable litigant. Having tried to do it, I can tell you that it makes clients feel frustrated and confused and leaves solicitors feeling quite inadequate. The plans also badly impact on women, especially in the categories of family, education and housing. 75% of domestic violence victims are women. 90% of single parents are women. 97% of those eligible for child maintenance are women. Women are more likely to be in non-unionised jobs, and men are more likely to be financially better off and able to pay privately. My firm over the years has looked after around 14,000 clients in the South London, Surrey and West Kent area, and the family profile that I describe is sadly not unusual. Mother presented with some learning difficulties, history of self-harm, drug abuse, but says that she's now clean. She has 3 children, all girls, with 3 different fathers. Father of eldest daughter seeks residence order and a contact order. Mother and daughter resistant in view of father's historic bullying and drunkenness. No previous injunction orders, but many police call-outs. All the girls are having problems at school, with middle daughter being diagnosed with ADHD. School have threatened suspension because of disruptive behaviour. Mother is on income support and being chased by loan sharks because of debt. Mother feeling suicidal and on antidepressants. All the children are on the Child Protection Register. When I took instructions from this lady, judging by her physical appearance and demeanour, I thought she was a woman of around 50. And it was only when I asked her for a date of birth that I realised she was just 25 years old. Under the current plans, this highly vulnerable woman would not be entitled to help with residence and contact applications. She would not be entitled to help with debt problems, and she wouldn't be entitled to help with her children's educational difficulties. This is what family life is like for many in our country. And these are the people who are relying on the family courts and legal aid to resolve their problems. Tragically, the children who are growing up in these families are watching and learning from the bad behaviour and absent boundaries and breeding future generations of victim and perpetrator. It really is a vicious circle. Legal aid cost $500 million in 1982. The cost is $2 billion today. I make no case for ring fencing from these cuts, and I see genuine need for reform.
I have a very high regard for her expertise in this issue, which greatly exceeds mine because of her practice. And the case she gives is very moving, but surely those things don't lend themselves to litigation. Our argument is not that we are going to leave those people with no support at all, but actually legal advice and litigation is not the best way of proceeding to resolve important social and family problems of the kind she's describing.
If matters like residence and contact could be resolved without litigation, and sometimes they are, that's a good thing. But unfortunately, dealing with a woman in the situation that I've described, with a man who's been historically difficult, drunken and abusive, those people sometimes naturally are not able to sort things out, regrettably. Continuing, we must accept that during the last 50 years we've created a social mess, in large part caused by the demise of the family unit and stalling social mobility. And we can't just pull the rug from under the feet of 500,000 people without any real and genuine alternative. As civil liberty is about freedom of our nation, civil legal aid is about protection of citizens. And for some, civil legal aid is the only sword and shield in their armoury. We must therefore wear kid gloves when handling this delicate aspect of the public purse. And for all the above reasons, I hope that further significant changes will be made to this important bill at committee and report stage.
Yeah.